I'm the big man attorney Joey Franks with Big Man Law here in Jackson, Mississippi. So we're back with Judge Middleton, but we're going to do something a little different this time. I'm not going to go over the super details of what's happening because you can watch the video and hear what he says. What I want to talk about on the backside is the procedures that are going on here with the attorneys, the motions, and what Middleton's doing. So enjoy, and I'll catch you on the flip side of this video.
As very often happens, sometimes emergencies come up, and that's why I'm here all the time, because you never know when they're going to arise. We are on the record, and the defendant is not here yet, but I'm going to call the case. The title of the case is People versus Janelle Ann Anthony. The file number is 241775FY. We have a host of people here. We have the entire public defender team, headed by Keith Stickley. We have Ross Truckee, who's been appointed to represent this defendant, substituting for Paul Gibson. We have prosecutor David Marvin. This is an emergency motion for, I'm not sure exactly what, modification of the bond. My understanding is the defendant was quite agitated at the time of her arrest. In fact, I'll tell you what I know about it. I was arraigning another person, and I called over and they brought a young woman, and they said, well, it may take a minute. We've got an unruly person coming from Three Rivers. I think I heard a little ruckus in the background. Well, that person was Janelle Anthony. I was at a meeting yesterday with the undersheriff, and he said she was still quite agitated. She's charged with assault with intent to commit great bodily harm, resisting, obstructing a police officer, ethnic intimidation, 2 counts of assault and battery. So we're about to bring her in. I asked the bailiffs to tell her that Judge Middleton wanted to see her and bring her in. So we'll see how this goes as I bring her in. And
there it is for you. Hi, Middleton.
good afternoon. Miss Anthony, can you hear me?
Yeah.
Okay, this is Judge Middleton.
Hi.
Hi, I wanted to talk to you. I've got a bunch of people here at the court with me. Mr. Keith Stickley, the Chief Public Defender, is here. Your attorney, Mr. Ross Truckee, is here. And prosecuting attorney David Marvin is here. Janelle, I don't know if you remember me, but I remember you from when you were.
I know my dad. I went to school with your son Alex. He was
yes, I remember.
He was a good boy. I liked him.
Well, thanks. He's still a good boy. He just turned 40. All right. You're charged with some very serious charges.
Yeah, they were
assault with intent to commit great bodily harm, resisting, obstructing a police officer, ethnic intimidation, and 2 counts of assault and battery. The magistrate set the bond in the amount of $10,000 cash or surety, and Mr. Truckee made a motion, and he wants me to review that bond.
Thanks, Mr. Truckee.
Your Honor.
Yes.
I had the opportunity, sorry to interrupt, I had the opportunity to review the video from yesterday, the arraignment. And the same sort of thing that happened yesterday from my point of view is happening now. I don't know if she's aware of what's going on as she sits there. I don't know if she's on the page. I don't think she heard a thing he said. And I know at any time anybody can make a motion for competency. And I would suggest that she assess for competency.
All right, Miss Anthony. Janelle? All right. Janelle, I'm going to let you go back to your cell. Brandy, you can take her back. All right, thank you. Well, that did not go well. Started all right. David, I don't think you helped anything. I was establishing some rapport and then it all sort of went sideways, but,
I don't agree respectfully.
well, I guess you don't have to. I had given the floor to Mr. Truckee to make his motion and you said, I don't want to interrupt, and then you interrupted.
Your Honor, may I say something else?
Yes.
I was looking at the computer screen. I don't know what you're looking at, but I saw somebody who had her head turned away from you and did not hear words you said. And I don't know if you're looking at the
I
YouTube
saw
monitor or
the
what
same,
you're looking
I
at.
saw the same thing you saw.
I would like to inquire, Mr. Marvin.
All right, well, first of all, let's back up. You made this motion. I'll read it. You don't cite any authority. You just made a motion. The reasons for the modification of the bond are failure to effect a proper arraignment on the defendant within 48 hours. There exists an unreasonable delay due to the ill will of the custodial officer during the arraignment hearing. The defendant was under threat or coercion during the arraignment, and the officer's actions jeopardized her constitutional right to make statements freely. Magistrate Autumn Kiefer probably was doing the same thing I'm doing, trying to do the best she could with a mentally ill defendant. And the unreasonable delay is not unreasonable because the delay is due to the mental illness of the defendant. And Mr. Marvin, I think, is on the money that we need to probably have a competency evaluation sooner rather than later. So, Mr. Truckee, what were you asking me to do?
I was asking you to find that the arraignment that was offered and is being tendered as an arraignment within the 48 hours was not a valid procedure, not due to Miss Anthony's unruly conduct or mental illness, but due to the conduct of the corrections officers that were present in the holding room with Miss Anthony. Twice the taser was directed at her head.
Well,
She was
let me back
directed
up.
to
What's your
comply.
authority for this?
Under MCL 764.13, 764.26, and People v. Cipriano all address the need for this 48-hour period. And it's United States and Michigan constitutions.
All right, well, let's take yesterday off the table for a minute. I just attempted to do an arraignment myself. The bailiffs were gentle with her. She was okay for a minute, and then she disassembled before our eyes. So whatever just happened was not as the result of conduct of the corrections officers. I asked the officer how she was doing. They said she was calmer today, but she had been crying all day. She's obviously suffering from severe mental illness. Problem in today's world is we can't tell how much is mental illness and how much is methamphetamine or both. The current configuration of methamphetamine helps create schizophrenia. So I don't know if that's what we're dealing with or she just is schizophrenic. The charges are very serious. Assault with intent to do great bodily harm. The booking information indicated that she jumped on some lady's back and broke her collarbone and said a bunch of racially charged hate stuff and fought with the officers, and it was a bad situation. So what you're asking me to do is essentially give her a PR bond or just discharge her?
I'm requesting that she either be granted a PR bond in this case with the understanding that she's on bond in a circuit court case, and that PR bond may not mean her immediate release. But I think in this file, she was denied due process by failing to be arraigned and failing to be afforded the ability to meaningfully participate, even though her participation isn't going to be terribly meaningful. A taser was aimed at her during the arraignment. She was directed how to answer the magistrate's questions. I don't think that in any way that can be found to be an effective process.
All right, well, the one we just did was, she's posted bond in the circuit court. As far as I know, there's been no motion to revoke that bond. I don't have the authority to revoke it. She's pled guilty, so she's no longer presumed to be innocent, so she's not entitled to a bond, but she has a bond and she posted it.
I'll
Now
indicate-
that was, she pled on the 24th of September, and this incident occurred on September 30th. So I'm not sure what happened between the time she pled in circuit court and the time she got arrested in Three Rivers.
I would indicate, Your Honor, I'm in possession of a complaint regarding her conditional release from Officer Dibble. Due to this alleged conduct, he's seeking that in a circuit court case, and it's suspected would be dealt with promptly.
All right, well, I'm gonna deny the motion for PR bond.
I did have an alternative request, if Your Honor would hear it.
All right, what's your alternative?
It may be based on the conduct during the arraignment, request that she be held at a different facility pending trial. It appears that it's unsafe for Miss Janelle Anthony at the jail.
All right, so you make an oral motion on the fly for me to remove her from the jail. So I'm not gonna grant that either. I don't know. I have faith in our jail staff. I know all of them. I knew the two ladies in the video. I don't know what happened yesterday. I know what I just saw. But the fact that we're gonna get a competency evaluation is gonna greatly delay this. And she's gonna be sitting there. So I don't know if there's any evidence that she's being mistreated presently. I did talk to the undersheriff about her yesterday. And couple issues. For the last several years, we've had Covered Bridge as our mental health liaison, jail diversion specialist at the jail. That contract ended September 30th and a new contract began with Pivotal. And frankly, we've had some bumps in the road. I had asked someone for some help with Aaron Brown. And I made 2 requests last week with no response. Got a response on Lisa's last day, September 30th. And then I sent an email to the director of Pivotal saying, will someone please help me with this guy? He's sitting in jail and he's got some serious mental health problems. And I haven't heard anything back. So right now, mental health is Pivotal, our county mental health, who decided to not call themselves Community Mental Health, but Pivotal, is connected to Miss Anthony, according to your petition or somewhere. Vicki Merrill's, it's in the bond information form, from Pivotal is presently supervising her. She was apparently capable enough on September 25th to enter a guilty plea in I guess it was no contest plea in circuit court, and Judge Stutzman accepted it. I'm not sure, as I stated a minute ago, what happened between then and now. Do you have a position regarding Mr. Marvin's request for a competency evaluation?
I'm not able to take a position on competency at this time. I was appointed to this afternoon. I've got to meet with Miss Anthony before I can speak on it.
All right, I'm denying the motion to amend or change the bond.
And the only further request I have, Your Honor, is that this court review the video of the arraignment.
As I said, I'm not worried about that arraignment. I'm worried about the one I just did.
I understand.
So I'll say I would set a $10,000 cash or surety bond based on the conduct, based on the fact that she was on a felony bond and had pled guilty 5 days before, based on the fact that someone had a broken collarbone. So if you want, I will set bond today.
Well, I might end up with a similar objection to this arraignment. But I would note that the conduct here was much different from the corrections officers.
All right, well, 10,000 cash or surety with the same conditions. It's greatly against the public interest to put this young woman out on the street. And it's against her interest. There's not a petition for hospitalization. She's on a personal recognizance bond in the circuit court. And if I were to grant your motion, she would be standing on the front steps of the jail in the condition that she's presently in. And I'm not willing to do that. And we're not talking about shoplifting or running a stop sign. She is accused of seriously injuring someone. And there's a public protection interest here and an interest to protect her. And I had this discussion with the sheriff yesterday, acting Sheriff Bingaman. Our jail is the largest mental health facility in St. Joe County. Of the 93 people in there, probably about 40 of them have mental health problems. Some of them are quite acute. And she certainly is. So she's connected to Pivotal. She is in a position where she can't harm anybody. I don't know if Pivotal would petition for hospitalization. They could do a police petition, or someone could petition or hospitalize her. As you all know, once you ask for a competency evaluation, it takes a long time to get there. Mary Finney was in jail for like 400 days before she got her competency evaluation, and she's not competent. So at any rate, the bond is set at $10,000 cash or surety with same conditions. The motion to transfer from jail, St. Joe County Jail, is denied. If there's additional evidence presented that she's unsafe or being unfairly treated at the jail, but she's just going to take her current problems to whatever jail I put her in. There is an option that somebody could petition for hospitalization. Mr. Marvin's motion for competency evaluation. I'm going to take that under advisement. Miss Anthony is set for a pre-exam conference for October 15th. Anytime before then and now, we can review it. She is working with mental health. I'd like some input from them. And I don't know, she's been like this for 4 days. I don't know that she's instantaneously gonna go into remission. I don't know enough about what's going on, but obviously what we all saw certainly begs for a competency evaluation. But Mr. Marvin, I think you made it in good faith. I'll take it under consideration. we can review it again between now and October 15th. And I'd like some input from CMH. Also, Judge Stutzman's going to have a problem. Someone from the Department of Corrections is going to be tasked with doing a pre-sentence investigation report on the case that she pled to, and thinking of a sentence on November 1st.
That could very well result in a report of competency concern.
Yes, he has the same problem I do. So perhaps if there's going to be a competency petition, it could be done in both files. Anyway, let's see how this goes. Hopefully, she will be prioritized by the female corrections officers. They do have at least one female on every shift. So, Mr. Truckee, you are doing your job that you're appointed to do, to look out for the interests of your clients, but I don't think it's in the best interest of the public or her to grant your motion. We can certainly revisit it. And I'll revisit your motion to move her to a different jail. And let's assume that there was some defect in the earlier arraignment, which, for just sake of argument, as I indicated, I heard some of it when she was coming in there. She was quite agitated on the way into the jail. I have the authority to set the bond. And for the reasons I stated, I would set the bond in exactly the same amount with exactly the same conditions based on what I just saw. So let's see what happens between now and October 15th or any further motions, but I'll do a written order denying your motions so you can appeal it or ask for something. But she is not in a position to be released into the public. And I guess mental health or you guys or somebody can consider a petition for hospitalization short of a competency evaluation, but I don't, if there's a motion in circuit court coming to cancel her bond there, it probably isn't going to happen anyway. So it is unpleasant to see Miss Anthony in that state. Let's hope she can get better.
All right, so we're back. We have a motion that is filed. So what happens in a motion when you file it, you put it in writing and it says, court, grant me this relief. In this case, they're wanting the bond changed up here. And you do that and you cite authorities. Well, authorities are case law. They are statutes. Ordinances come into play, especially municipalities. You get off into some places, administrative law comes into play, or administrative code sometimes, as you hear it called. So all those are laid out, and you present your case, you present your arguments, and the other side has an opportunity to respond. In a lot of courts here in Mississippi, you get 10 days, and sometimes it changes to 14 or 15 or even 20, just depending on where you're at. The Workers' Comp Commission is different than, for example, circuit court on most pleadings, and the circuit court will be different than the chancery court, so you have to keep up with your specific rules. So the attorney has submitted a motion. The other side's had an opportunity to respond. And I like how you have Judge Middleton say, what is your authorities? What are you relying on for this? So many attorneys will put a motion together that says, hey, court, please give me the following and any other proper relief you deem proper. It's bull. Go cite something, man. Go in there and say, Bull Cummings v. New Mexico and the 6th Amendment say that they've got to produce somebody from the forensics laboratory. They won't do that. And then, Bull Cummings v. New Mexico is a U.S. Supreme Court case. You get off into some parts of Mississippi, and the judge will look at you and go, well, that's a Supreme Court case. It don't apply here. I've had that happen legitimately. And I learned very early on, because of that happening, that what you do is you go and you bring the state law that does that. And by the state law, I mean you find the case from the Mississippi Supreme Court that says, yeah, the U.S. Supreme Court says we got to do it this way, so we're going to do it that way. And that's why I carry both those cases now in my trial binder whenever I show up on a possession case, for example. So I can cite Bull Cumming v. New Mexico, then I can turn around and whip it out what it says for the state, and I go and I update the state case ever so often because it may change. So. But you can also rely, like I said, on the Sixth Amendment of the U.S. Constitution. Then you can drop down and find the corresponding part of the Mississippi Constitution. And you've boxed them in. All of a sudden, they've got to produce this person. But if you have a written motion, you don't have any of that in there. What's the judge supposed to say? Well, I don't feel, no. That's just lazy lawyering if you don't do that. So you get the motion presented. They have it out, and the judge is going to rule on it. But he makes an oral motion, and that's referred to, I've heard it said two ways, or tennis or a tennis. Just depends on who you see. Everybody knows what you're talking about in court, so, and nobody goes and goes, oh, you didn't use the proper Latin term. No, we don't do any of that stuff here. But what happens then is say you've been surprised by something at the last minute. I've been ready for a jury trial. We've picked a jury before. That was on a Monday, and on a Tuesday we were supposed to start with the trial. And 2 minutes before opening statements, the district attorney walks over and hands us a flash drive and said, that's your client's confession. Jack, you've been sitting on this for 2 years. So obviously we made a motion to dismiss or to exclude, or an alternative to continue. And we did an oral motion, which means nobody filed any kind of written documentations. And generally you know enough cases off the top of your head to start citing some of them that are applicable. And it's real, it's shooting from the hip. Nobody particularly likes to do it. But when you're presented with a situation, you have to do it. And that's what the attorney is doing here. And it's fun to see how Judge Middleton is handling all that. And he denies that motion. So that's what I liked about the video. We all see folks, unfortunately, that have the mental problems. We've all heard about the mental problems in the jail system. And Judge Middleton does a pretty good job of talking about how 40 people out of about 93 have mental health problems there in their particular county. So there's a lot of videos out there about that. There's a lot of videos that show folks getting their bonds and show folks acting up or showing their issues, or maybe their drug habits coming out, or the withdrawals from the drug habits coming out. But there's not a lot of explanation I've seen on the kind of inner mechanics of making motions and responding to them. And I thought that was the fun part about this video. I really enjoyed watching that part, because that's how it goes down a lot of times. And say you file a written motion and you get granted in part and denied in part. Well, if you were denied in part, you might need to go do something to try to fill in that hole. And that's where you'd make that or tennis motion and say, Your Honor, at this point we move for, and maybe it is a psychological evaluation at that point in time, because the judge excluded one thing, but he said, I'm gonna let this in right now. Well, Judge, we need to see whether or not that really is proper to let in based on your ruling, and you get where I'm going with this. So, kind of the inner workings on how a motion works and a hearing works and how we do things. I enjoyed it. So, hope everyone has a great day. Thanks. Oh, I'm gonna get in trouble if I don't ask you to subscribe. And also, if you have thoughts on this, I always like reading the comments. I really do read a lot of them, and I respond to a lot of them. I probably read close to all of them. Anytime I have any kind of downtime, I break it out and start checking it out. So leave your comments. Some folks make some really good points. I even had somebody point out that I was wrong about something in Michigan law. So tell me, and I'll check it out, and I'll tell you whether or not you're right or wrong on calling me to the mat. So a lot of fun. Enjoy these videos. I hope you do. Thanks.